So, Assemblyman Cooper, followed by Assemblywoman Lopez, and thank you, Assemblywoman, you've been very patient. No.
Thank you, Madam Chair and members. AB 989 will clarify that in cases where a juvenile record has been sealed, if a youth subsequently returns to the custody of the juvenile court, probation may access limited information to develop a case plan to best address the treatment needs for the minor. This bill is clean up to last year's SB 1038, sponsored by Senator Leno, that provided automatic dismissal of juvenile records. This bill is narrowly crafted that addresses the probation's access to certain records when the youth is brought back into custody on a new crime, so probation can make the best case plan and treatment plan for the minor. AB 989 upholds the intent of SB 1038 and will assist juveniles on their path to becoming a productive member of society. This bill has bipartisan support and has received no votes. It is sponsored by the Chief Probation Officers of California and the State Coalition of Probation Organizations. I respectfully ask for your aye vote. And with me, I have two witnesses to provide clarification.
Thank you. Speakers in support of the bill.
Madam Chair and members, Danielle Sanchez on behalf of the Chief Probation Officers of California, pleased to be the sponsor of this bill. This has been kind of follow-up to, of course, to SB 1038 by Senator Leno, certainly a mission that we support and are seeking to assist with. But one of the things we've learned kind of upon implementation is that when a minor comes back into our custody on a new petition, that we do not have access to our previous program and service referrals. And so under the header of really trying to determine the best case plans possible, we're looking in a very, very limited scope to ensure that just on those limited new petitions for a felony offense, that we are able to look at previously where we referred them to, whether it was a substance use issue or different programs. The few other things that this bill seeks to do is just to make sure, again, only when that minor comes back into our custody on a new felony petition, that we are able to determine their AB 12 extended foster care eligibility, informal probation, and then Title 4E compliance, which is the federal program that allows the state to draw down dollars for foster youth in our custody. So we are really looking at this in a very, very limited scope and solely looking at it from when the youth comes back into our custody on those limited cases. So for those reasons, we ask for your support today. Thank you.
Thank you. Others in support?
Yeah, good morning, Madam Chair and committee members. My name is Paul Brennan. I'm the president of the State Coalition of Probation Organizations. I'm also a probation officer in San Joaquin County right next door. So it's been very interesting to hear the discussion over the last 45 minutes. Certainly have some of the same concerns you do with regards to addressing the needs of the minors that come into contact with our department. Passage of AB 989 would grant probation officers limited access to juvenile files in situations where there is a subsequent arrest of a juvenile in order to inform the probation officer's recommendation for rehabilitation program referrals, risk needs assessments, and other placements. Obviously, you know we're a arm of the court, so we need to have access to those files. Once a juvenile has completed their term of probation, current law limits probation officers' access to juvenile records. As a result, without access to the closed files, the probation officer has no ability to determine the proper course of action as it pertains to placement and or rehabilitative placement of a juvenile who is rearrested prior to the age of 18. This prohibition, this prohibition also inhibits the probation officer's ability to provide a comprehensive dispositional report to the court. This legislation is vital for the proper performance of a probation officer as it relates to the access of juvenile records for the purpose of making an informed recommendation to the court. We're asking your support on this bill and ask that you go aye with it. Thanks.
Thank you. Others in support? Others in support?
Sean Hoffman with the California District Attorneys Association in support of this important reform measure. Thank you.
Andrew Langley on behalf of the County of San Diego in support. Thank you.
Ryan Sherman with Los Angeles County Professional Peace Officers and the Sacramento County Deputy Sheriff's Association in support. Thanks.
Go ahead,
John Lovell Association for Los Angeles Deputy Sheriffs. Los Angeles Police Protective League, Riverside Sheriff's Association, and Los Angeles County Deputy Probation Officers in support.
Others in support, excuse me. Speakers in opposition to the bill.
Members of the committee, Jesse Stout, Legal Services for Prisoners with Children, in respectful opposition to AB 989. We think that AB 989 undermines the intent of California's confidentiality statutes. California confidentiality laws are intended to protect children from present and future adverse consequences and unnecessary emotional harm. Juvenile courts are intended to have exclusive authority in determining whether a juvenile record is to be sealed. Under current law, entities must petition the court to obtain someone's confidential juvenile record. This process gives the defending party an opportunity to contest the sharing of information that may be detrimental to his or her rehabilitation. AB 989 would add a new section to Section 786 to grant probation departments access to sealed juvenile records for the limited purpose of determining program referrals, quote, solely to determine the individual's eligibility or suitability for remedial programs or services, unquote. This proposal is unnecessary because district attorneys already make informed decisions to refer young defendants to programs regardless of probation records. Since district attorneys already have access to sealed juvenile records to decide program eligibility, probation department access to the same records is unnecessary. Additionally, we're concerned that it will be difficult to limit access to what is solely necessary for this purpose, and difficult to know whether access was limited in this fashion or whether probation officers use this information for other purposes. So for these reasons, we respectfully ask for your no vote on the bill as drafted. Thank you.
Are there questions or comments from members?
Madam Chair, we've had this conversation a bit already. Some of them appreciate your follow-up work on our bill from last year. If we could just hear from the proponents as to the response with regard to Mr. Stout's concerns that the information may be used more broadly than what is intended by the author.
Absolutely. I would say two things. First, we worked very closely with the advocates that were the proponents of your bill to ensure that we were not undermining anything that was done in that statute. We did in the bill add a provision that ensures that when the youth comes back into our custody on a new petition, that the information that we can use for their program and service referrals, it explicitly says cannot be used for any sanctions or in a punitive manner. So we're very careful to say we can access it, but it can't then be used in a manner, I think, that would get at what the opposition is stating. So we've tried to add some safeguards around that.
All right, thank you.
I have a question. Just to follow up on that, it appears as though, in spite of the bill that was enacted last year, information is getting out in a way that's detrimental to the young people. Now, how would that happen? And what would the safeguards be to be explicitly the concerns that were raised in the opposition letter?
I would just, Madam Chair, I would say, I certainly can't speak for the larger scope of how other groups may perceive information to be getting out. For probation's purposes, we're only looking to use this type of information when they come back into our custody. If they successfully complete probation and have their records sealed, that is the ideal situation.
I'd actually like the opposition to be able to stay at the table. Could we make some room? Thank you.
If the minor were to successfully complete their probation, that is the ideal situation. That's ultimately what our mission is. And so I haven't heard issues of information getting out beyond where it's supposed to. I think right now it's a matter of there's varying legal interpretations as to what may be sealed or not.
That's correct. And I think it is problematic, especially with us being an arm of the court. We need to have access to information to at least be able to make an informed decision. Otherwise, we're doing the service or disservice to this criminal justice system. That's the reality of it.
Madam Chair, Many, many years ago, I was the commander of the downtown jail. When inmates came back into custody, there's no use in reinventing the wheel. So when we went back to their charts, it's not for punishment. And the purpose of this bill is to find out what were their mental health issues and domestic violence, substance abuse, GED. So there are a lot of components we do that we use that we want to rehabilitate this person and not punish them and get them back on the right track with that. I get it. It's important to sell records and give them a fresh start. But also you got to know where you're coming from in order to get them there. And that's so important because if someone's had mental health issues, you want to build upon that. So that's so important, having seen it firsthand. That's the key to it.
Well, at some point, you're absolutely right. It's an assessment issue. And then the question is how that overlaps with issues of privacy and rehabilitation and a fresh start. And
I would also add that, especially, for instance, the GED, a lot of folks don't have a high school diploma, so they've
Right.
come in, they completed part of that coursework, they come back in, okay, where do we start from at this point? So there's a myriad of things. It's a very complicated issue.
Right.
But in the end, like I said, I think this is a narrowly defined scope to try and get us there with these juveniles.
Just if I may add one last thing, and we're sometimes, a lot of times, tasked with the responsibility of the parent because the parent's either not there or unable to provide services to that child. If we're not the parent, we don't have direct information on that individual. And so without access to those records, how, again, can we make a decision based on some rationality, based on previous referrals? How are we going to be able to make an informed decision about what type of treatment or services we could provide?
Senator Anderson?
I think this is one of those issues where the information in the right hands is a good thing. The information in the wrong hands is a bad thing. And I think trying to eye this needle is very difficult, but I think that you've made a real solid attempt at doing this, and I'd like to support the bill today by moving the bill.
Senator,
Say a motion.
Stone.
Thank you, Madam Chair. I want to just applaud Assemblyman Cooper for bringing this forward. I think this is a common sense approach to doing what we can, I think, to even address the chair's concern to give these kids the best outcomes that we possibly can so they don't recidivate back, and certainly having some information available to them, understanding the traumas that they may have undergone in their past. And I love the parenting example. You've got to have some background on these kids if you're going to have a rehabilitation plan to bring them out of the criminal justice system. And for that reason, I'm happy to support the motion.
Yeah, thank you. So the bill has been moved. I'm going to support the bill today, too. What I would like, Assemblyman Cooper, because I realize that Assemblyman Stone's bill is somewhat broader, but there are things in it that we want to protect and that we like, is a commitment that if both of these bills pass, and if both of them, this bill is not going to appropriations, but if both these bills pass, the two of you would sit down and work on chaptering issues so we get something that can address the whole thing.
You have my commitment, Madam Chair.
Okay. Thank you. Okay. Please read the roll. Oh, would you like to close? I'm sorry.
I respectfully ask for your aye vote.
Yeah.
Hancock.
Aye.
Hancock, aye. Anderson.
Aye.
Anderson, aye. Glazer.
Aye.
Glazer, aye. Leno.
Aye.
Leno, aye. Liu. Monning. Stone.
Aye.
Stone, aye.
Okay. That has enough votes. We'll hold the roll open for the absent members.
Thank you.
And Assemblywoman Lopez. And we appreciate your patience very much. Our last bill of the day. AB 1207.
Thank you, Madam Chair and members. AB 1207 will help keep our youngest, most vulnerable children safe from child abuse and neglect by requirement they report and license child care training and recognize signs of child abuse and how to report it. Child care providers are a critical part of the early care and education system regarding the training and recognize the reporting child abuse will help be fully effective in carrying this role. And I have with me Lawrence and testimony to share.
Thank you.
Good morning, Madam Chair and Senators. My name is Lori Furstenfeld, and I'm a staff attorney at the Child Care Law Center. At the Child Care Law Center, we are experts in helping families obtain and keep their child care. We are the agency sponsor of AB 1207, and I am also a former social worker with an MSW who's worked with children and families. I'd like to thank Assemblymember Lopez for sponsoring this important piece of legislation to help keep children safe. AB 1207 was born out of the statewide health and safety regulatory work group, which is comprised of experts and professionals throughout California who are dedicated to improving the quality of childcare in California. We worked on a subgroup that was dedicated to helping prevent child abuse for children in California childcare. In this work group, we found through our research that children ages 0 to 5 are the most likely to be abused and neglected and the most likely to die from abuse. We also found that training is a key deterrent to helping children from being abused. Training the professionals who work with these children and recognizing the signs of abuse and, when appropriate, to report it. We found that child care providers, although they are mandated to report suspected child abuse, and they are liable if they don't report such abuse, they're liable criminally, they're liable civilly, and they're also subject to license revocation. They are not required to take any training in how to recognize signs of child abuse or in how to report it. We also found that...
I would just say there is no opposition to the bill.
Oh, okay.
And
I'll speed it up.
thank you.
So the training is available. It's free. It's online. And we respectfully asked for your support of this bill. Thank you.
Thank you. Others in support?
Good morning, committee. My name is Nancy Harvey, and I'm a child care provider in the city of Oakland. I have owned and operated my business, Little Nancy's Primary Schoolhouse, for almost 13 years. I, along with many other providers in this great state, would benefit greatly from the passing of AB 1207. As a child care provider, I'm also a mandated reporter. However, like many other providers, I have never received formal training on how to recognize or report child abuse. Several years ago, I can recall a single mother of two enrolling her 2-year-old son, Jaden, and 4-year-old daughter, Sanai, into my child care. Due to the cost of diapers, the mother was very eager to potty train her 2-year-old son, Jaden. However, Jaden simply wasn't developmentally ready to be potty trained. Like most toddlers, he had trouble making it to the bathroom on time. So quite often it resulted in an accident in which his clothes got wet. One particular morning while eating breakfast, I noticed a puddle near his chair. I commented to him, "Oh, we forgot to go potty." His older sister yelled at him and said, "Jaden, Mommy's going to get you for messing up your clothes." As I began to change Jaden, I noticed his buttocks and genital areas had whelps on them. I was in utter shock. I couldn't believe what I was seeing. The image of this little boy still haunts me today. I knew I had to do something. However, what was that something? Was I to call 911, contact Child Protective Services? I really did not know. Fortunately for me, my neighbor was a CPS worker. And once I made the call to her personal cell phone, she guided me through the process of reporting this incident. Studies have shown that children under the age of 5 are the most vulnerable to abuse and neglect. These young children spend more time with providers than any other adult outside of their families. If properly trained, providers could prevent child abuse and even recognize a parent who might be struggling emotionally and could benefit from a parenting class, which ultimately would protect the most vulnerable child. So on behalf of the children of the state of California, I ask respectfully for the committee to vote in favor of AB 1207, which would require all licensed child care providers to receive formal training on how to recognize and report child abuse and save our most vulnerable children here in the state.
Thank you very much. I think the rest could do Me Too's.
Madam Chair and members, Bron Shea Jones on behalf of Knowledge Universe and our nearly 200 centers in support.
Thank you.
I am Brandon Roberts. On behalf of the Health Officers Association of California, we're standing in support.
Thank you.
Rebecca Gonzalez, National Association of Social Workers, California chapter, in strong support.
Thank you. Are there others in support? Are there speakers in opposition to the bill? Seeing and hearing none, are there questions or comments or a motion from members of the committee?
So moved.
The bill has been moved. I think this is a very important and very, very good bill. I rarely do this, Assemblywoman Lopez, but as the bill moves forward, I would be honored to be added as a co-author. Training in something like this, especially if it's provided by the state and it's free, is exactly, I think, what we need to be doing. It's very good. So, would you like to close?
Yes, I respectfully asking you for your aye vote. Thank you.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Glazer? Glazer, aye. Leno?
Aye.
Leno, aye. Liu? Monning?
Aye.
Monning, aye. Stone? Stone, aye.
Thank you. That bill has enough votes. We'll hold the roll open for the absent members. Would the sergeants please call the absent members? We do, and for the members that are here, we'll start to go through. Item 1, which was on consent, please call the absent members.
Hancock?
Aye.
Hancock, aye. Monning?
Aye.
Monning, aye. Stone?
Aye.
Stone, aye.
Okay, consent calendar is passed. Item 2, AB 487 by Gonzalez. Chair voting aye, vice chair voting aye.
Leno?
Aye.
Leno, aye. Stone?
Aye.
Stone, aye.
Okay. 7-0. That bill has passed. Item 3, AB 526 by Holden. Vice chair voting aye.
Hancock?
Aye.
Hancock, aye. Monning?
Aye.
Monning, aye. Stone?
Aye.
Stone, aye.
Okay, 7-0, that bill is passed. Item 546 by Gonzalez, chair voting aye, vice chair voting aye.
Leno?
Aye.
Leno, aye. Monning?
Aye.
Monning, aye. Stone?
Aye.
Stone, aye.
7-0, that bill is out. We put over item 5, item 6, SB 673 by Santiago. Vice chair voting aye.
Hancock?
Aye.
Hancock, aye. Monning?
Aye.
Monning, aye. Stone?
Aye.
Stone, aye.
7-0. That bill is out. Item 7, AB 835 by Gibson. Chair voting aye, vice chair voting aye.
Monning?
Aye.
Monning, aye. Stone?
Aye.
Stone, aye.
Blue, I don't have a vote. Oh, okay. 7-0, that bill is out. Item 8, AB 899 by Levine. Chair voting aye, vice chair voting no.
Monning?
Aye.
Monning, aye. Stone?
No.
Stone, no.
Okay, 5-2, that bill is out. Item 9, AB 909, chair voting aye, vice chair voting aye.
Monning?
Aye.
Monning, aye. Stone?
Aye.
Stone, aye.
7-0, that bill is out. Item 10, AB 989 by Cooper, chair and vice chair voting aye.
Liu? Liu, aye. Monning?
Aye.
Monning, aye.
7-0, that bill is out. Item 11, AB 1168 by Salas, chair and vice chair voting aye.
Leno?
Aye.
Leno, aye. Stone?
Aye.
Stone, aye.
7-0. That bill is out. And item 12, AB 1207 by Lopez. Chair voting aye, Vice Chair voting aye.
Lou, aye.
7-0. That bill is out.
Thanks, Lonnie.
That concludes the agenda, and it concludes our meeting.
Hold on.
What?
Oh,
We put over.
It was put over. Yeah, we put it over for 2 weeks.